Hello, welcome to the Meyer Associates Protecting Your Family Year-End Update. My name is Justin Meyer. Before we get started, a quick disclaimer. This presentation is designed to give general information about the topic and does not constitute legal, financial, or accounting advice. Before taking any action, it is recommended that you speak with an attorney, accountant, or investment professional. A little bit about me. I'm an attorney licensed in New York, New Jersey, and Florida. I'm one of the attorneys with Meyer Associates. I publish articles on investing and due diligence best practices, and I work with families and small business owners on estate planning and other legal issues. Our presentation today will cover a couple of topics. We'll start with estate planning for the year end. Then we'll look at beneficiary information and powers of attorney. So first, let's look at estate planning. The big question to ask is, when was the last time that you reviewed your documents? Your documents include any trust that you have, your will, healthcare proxy, power of attorney, and a living will if you have one, as well as any other documents that may have been created for you. It's recommended that you review them every 5 years, and to be honest, some of them you want to review even more frequently. Any trusts, probably want to review them every 3 to 5 years, but a will, you probably want to review a little more often. Power of attorney right now, you probably want to review a little more often as well, because the laws on powers of attorney are changing, and we'll talk about that later on. A living will you want to review, even if it's not with your attorney, to make sure that it matches what your wishes are. Powers of attorney are important because healthcare proxies and living wills are important because that's where you can express your wishes for any kind of end-of-life care. And it's important that you make sure that what you have on there is what you want. The end of the year is the best time to review all of your documentation because it's now that you're going to start gathering your financial information for tax purposes. This lets you take a look and see if your financial situation has changed at all. So think about this. What has changed in terms of your assets? What has changed in terms of your family? Is your family makeup now different than it was when you originally drafted these documents? It's especially important because some attorneys will name your children in your will, and you want to make sure that if they do that, then all of your children are named. If you've added more children, then they need to be accounted for if you want them to inherit. Another thing to think about is, are the people that you named in your will still the people you want to take care of things? If you named your best friend 5 years ago as your executor, is that person still your best friend? Some people have named a childless relative, an unmarried aunt or uncle, as the guardian of their children, but now that person has children of their own. Do you still want that person to be your child's guardian if something should happen to you? You want to think over, again, who you are naming and who you have named. Are these still the best choices for you? As you take a look at your assets, you also want to consider, are there any specific gifts that you want to make? Are there any gifts that you made that you no longer want? You may have in the past left nothing specific to your children. You may have just left them your entire estate, but now maybe you want your children to take one child to take one particular gift and another child to take something else. If they're small personal items, you can handle that through a letter. Family heirlooms, jewelry, that sort of thing can generally be handled through a letter. Doesn't need to go through your will. But things such as stocks, that should have, if that's a specific gift that you want to make, that should go to in your will. If you have any charities that you feel you now want to leave donations to in your will, that also needs to go in there. The other thing that's important to make sure about is, have you ensured that your retirement accounts, investment accounts, and life insurance policies all have the right named beneficiaries? One of the most common mistakes that we see is that people don't change their beneficiaries at all. It's important to make sure that you do that. It's important to make sure that the beneficiary is not going to end up being your estate. One recommendation that we always make is for a life insurance policy, make sure your named executor is one of the beneficiaries, even if it's for a small amount, just so they have cash on hand. It's important to make sure you know that if you have a trust for your children in your will, you can have the trust named as a beneficiary of your life insurance and retirement accounts. If you have an attorney and a financial planner, have them talk to each other. The attorney can give the financial planner the information in the will. The financial planner can get that information, and they can draft the documents that you'll need together. Let's talk a little bit about powers of attorney. There have been lots of changes in the laws that govern powers of attorney. In two of the states that I practice, New York and Florida, there have been major changes over the past 5 years. And again, like I said before, even though we recommend having your documents looked at every 5 years, when there's a change in the law, it may mean that you need a change in your documents earlier. Most states have the same premise that while a non-conforming power of attorney that predates the new law should be accepted, there is no guarantee. People are expecting to see a certain format of power of attorney. If they don't see that, there could be problems. Banks have been known to not accept non-conforming powers of attorney, even if they predate the law that makes them non-conforming. It's important that you make sure that your power of attorney will be accepted, and it's important that you make sure you have the most up-to-date power of attorney. So as I said, it's best to review the document. It's best to have an attorney take a look at it. Make sure that it conforms to the current law. And while you're having it looked at, you might want to make sure that it has everything that you're going to need in it, including a choice of guardian. Guardianship is becoming a bigger thing. It's becoming a more costly thing. What this basically means is somebody to take over your affairs if needed. If you don't name somebody, then the court will. So just like when you would name an executor for your estate or a guardian for your children, you want to name somebody who you want to be your guardian. And most of the time you make that choice in your power of attorney. Some states have what's called in various ways a pre-need guardianship form or a guardianship selection or guardian selection. Florida uses them. New York does not. New York, we put it into the power of attorney. In Florida, we do that as well, but we can also create a pre-need guardian form. It's important that you have these forms because if a guardian, as good as a power of attorney can be, sometimes you need a guardian appointed, and if a guardian is to be appointed, then you want to be the one choosing who your guardian will be. While this is just a request and the court can name anybody, generally the court will look to your requested person, and unless there's a particularly good reason, that's who they'll choose. We have some other resources. We put out a monthly newsletter, and we have our blog, Legal Notes. To get to our newsletter, you can go to meyeresq.com, that's our website, and click on resources. Our blog, you go to http://legalnotes.meyeresq.com, and that will get you there. If you have questions about anything that was discussed, please feel free to contact me. I can be reached at jmeyer@meyeresq.com. Thank you very much for joining us, and I hope to speak with you sometime soon.